SJC-11857, Commonwealth versus Lawrence Moore.
Thank you. While we're waiting for council to approach, I want to welcome the students from the Greater New Bedford Regional Vocational High School, as well as the City on a Hill Charter School. And I trust you will go back to your classrooms and decide each of these cases on your own.
Good morning, Your Honors. Rachel Van Duren for the Commonwealth, asking this court to vacate the order allowing the defendant's motion to suppress. As this court knows, there is currently no case law in Massachusetts articulating what Article 14 requires for a search of a parolee to be reasonable. And it is the Commonwealth's position that the motion judge, in acknowledging that absence of governing law, erred in applying the standards set forth in Commonwealth v. La France, which governs searches in a probation context, to the facts in this case where we have a search of a parolee. And it seems that that error stems from the motion judge's statement in his memo and order that there is little, if any, difference between probation and parole. It is the Commonwealth's position that that is simply an incorrect statement. And I urge this court to look at the United States Supreme Court's holding in California v. Sampson and the analysis there discussing at length the differences between probation and parole, particularly the differences in expectation of privacy and the government's interest in supervision. And I also urge this court to engage in a comparison between the institutions of probation and parole, particularly in how a person comes to find themselves under parole or probation supervision, how the institutions, or rather agencies, are structured, how parole or probation are revoked.
Counsel,
yes, Your Honor.
I could agree with you for a moment that that there are differences, but how does that get you to a completely warrantless search without without any reasonable basis? That it doesn't automatically follow that because they are different, that the parole officer would be able to do what was done in this case.
Well, Your Honor, first I would suggest that this was not a search absent reasonable suspicion, but going to the first part of your question, it is not just that parole and probation are different. It is that when we look at the analysis set forth in Sampson, it is that the privacy expectation is significantly lower in a parole context, and that the government's interest in a close supervisory relationship is significantly heightened, that as the Supreme Court said in Sampson, may eliminate the necessity for a particularized suspicion requirement or a warrant.
But are you I didn't think you were arguing that this, well, maybe you are, that parolees in their homes can be searched at any time for any reason or no reason at all. I thought you were arguing that there needs to be reasonable suspicion of a parole violation in order to justify such a search, or am I wrong?
My argument is that something less burdensome than La France is appropriate in a parole context. Whether this court chooses to go all the way to the standards set forth in Sampson would be up to the court's discretion. And arguably, it would not be searches at any time, at any reason, by a parole officer, because the parole regulations require that officers can only undertake such searches that are deemed necessary.
But that's just by regulation. We're talking about the Constitution now. So
right, but
if the regulation changed, that would be okay?
Well, right now we do have the regulation, and I would point to in Sampson. In that case, the Supreme Court said that there was not a need for a warrant requirement, in part because of the government's interest in supervision, but also because California did have a law stating that essentially there could not be arbitrary or capricious searches. So I suggest that the regulation in Massachusetts here, stating that there can only be such investigations as are necessary, does serve a similar function.
Well, leave the requirement of getting a warrant aside.
Mm-hmm.
So sort of take the Terry situation, Terry search situation. Reasonable suspicion is enough. You don't have to go get a warrant
Certainly.
for a Terry search, right? Or Terry
Yes.
stop.
Yes.
So would that satisfy you?
Yes, Your Honor. The Commonwealth is more than anything seeking clarification on the law and asking that there be acknowledgement of the differences between probation and parole, and that the standard be something less burdensome than LaFrance.
But one of the differences between probation and parole is that revocation is decided by a parole board and not by a judge, and there's no judicial review. So if we say you do not need a warrant, it's the parole board. Is the parole board supposed to be enforcing the reasonable suspicion standard? An executive body with no judicial review?
My understanding is that is currently how the parole board functions, and the parole board does exercise that type of discretion in other avenues. The parole board on its own can detain a parolee for up to 15 days just based on a parole supervisor's approval and based on reasonable suspicion, not just that the parolee has violated the conditions of parole, but reasonable suspicion that the parolee is about to lapse in complying with their conditions of parole would be enough for detention up to 15 days. So that ruling, I do see Your Honor's point about investing that kind of power in the parole board, but it does seem that parole already has that type of power, so this is very consistent with the way that the agency functions.
And the parole board is indeed the board that's decided upon release. It's not a court that's
Exactly.
decided upon release. This is very conditional release.
Where we have probation, the court orders a defendant, the defendant is sentenced to probation. Parole is a very different situation. We have a person who is incarcerated applying to the parole board for the benefit of completing the sentence outside of prison walls. And it is a completely discretionary decision by the parole board. The parole board need not, and the regulations specifically say, need not allow parole even in situations where parole would be appropriate. It's completely discretionary. So it is a very different framework here.
Can you be a little more specific about what it is in LaFrance that you think is inappropriate in the parolee context? What is it that you don't like about LaFrance?
Well, particularly the warrant requirement would seem odd in a parole context, particularly because, as I just discussed, parole officers do currently have the ability to detain a person for up to 15 days without that type of warrant requirement, so it would seem odd that parole officers would then need a judicial warrant simply to investigate and conduct searches. It simply does not fit with the way that parole currently operates. And also parole in general, and particularly in this case, it's very distinguishable from LaFrance because the privacy expectation is so much lower. The motion judge in this case did make a finding that the parolee here had really no greater expectation of privacy than the parolee in Sampson. And in Sampson, the United States Supreme Court said that parolee did not have an expectation of privacy that society would recognize as legitimate.
But I think I'm summarizing what you've said, but you're saying your position isn't really that reasonable suspicion isn't an appropriate standard. It's really the fact of does it have to meet the warrant requirement in that there can be no search either without a warrant or without one of the recognized exceptions to the warrant requirement. So reasonable suspicion is okay as far as the Commonwealth is concerned. Is that? I mean, that's not the Sampson standard, but...
Certainly. The Commonwealth's assertion is simply that something less burdensome than LaFrance is appropriate. So certainly just a standard of reasonable suspicion would satisfy the Commonwealth. We just don't want to preclude this court from applying Sampson if the court does see fit, as this case is certainly similar in many ways. And this court has not, at this point, articulated that in a parole context, Article 14 requires more than the Fourth Amendment.
But you do acknowledge that the parolee has some expectation of privacy.
It's more than what a prisoner is.
Yes, we are not likening parolees to prisoners. On that continuum of punishment, starting with solitary confinement and ending on community service, they are close together, probation and parole is also somewhat close to imprisonment, but certainly these are all separate points on that continuum.
There's no institutional security issue.
Exactly, there's no institutional security issue, there's no health concerns. The Commonwealth is, of course, not suggesting anything like strip searches, which would be allowed in a prison context, would by any means be permissible in these situations. We are simply saying that parole is inherently different from probation and that the privacy expectation is less and that the government's interest in supervision is greater.
So does that mean that it would be inappropriate for parole to condition release upon waiving any rights to a search of one's home?
I believe that if I understand Your Honor's question correctly, I think that might be how parole is currently operating.
That was
So
the New
you're
Hampshire
basically
standard.
in New Hampshire.
Right.
But are you saying that Massachusetts could say, we will parole you as long as you agree that we can search your house whenever we seek to for any reason?
My understanding is that that is how Massachusetts parole works.
And then how is that different then from a prison cell? If they
To
can-
search at any time.
If you basically say you get parole only if you agree that we can search your home at any time, how is that different from being in a prison cell, which you can also
Well,
search anytime?
the person who was sentenced to a full term of incarceration is given the benefit of serving that prison sentence in their home rather than in a prison cell. And additionally, parole officers are bound by the regulations set by the parole board, which again only allows such investigations as may deemed necessary.
Okay, but you're speaking out of both sides of your mouth. You're saying it matters that you're no longer in a prison cell and you have some rights in your home greater than that of a prisoner, and then you're saying, but we can condition parole on your agreeing to give up those rights and say you can search us whenever you find it necessary.
My understanding is that is how Massachusetts parole currently works.
And is that constitutional?
I believe that it is. The Supreme Court has found it constitutional under the Fourth Amendment. If this court finds that Article 14 requires more, then
That's the question in this case.
Right.
Does Article 14 require more?
I would suggest that it is constitutional. This is a person who was sentenced to a full term of incarceration, at which point there are no Fourth Amendment rights. The fact that they are allowed to complete the sentence outside of prison walls does certainly give them a somewhat greater expectation of privacy, but only incremental.
Does the government need to have a reasonable suspicion that a crime has occurred before it can walk into a parolee's house, or can it really do so for absolutely no reason at all?
Well, right now, there's no suspicion requirement. In Massachusetts, as Officer Jackson testified to at the motion to suppress hearing, Massachusetts has something called a consent to search provision, which I understand to be the equivalent to New Hampshire's.
But I thought you suggested earlier that reasonable suspicion would be an appropriate standard to search the person of a parolee.
I'm sorry, I'm not following the question.
Didn't you
Your
say
Honor.
earlier that reasonable suspicion would be an appropriate standard to search a parolee?
It certainly would be, but that's not the standard that's required right now.
Okay, what is the minimum standard that's required?
Right now, there really isn't a particularized suspicion requirement in Massachusetts for searching parolees.
There's just
There just
no
isn't
law
case
either
law
way.
discussing
Yeah.
Article 14 in a parolee context, which is why the motion judge looked to Commonwealth v. LaFrance discussing these issues in terms of probation. So what we have is we look to the Fourth Amendment analysis undertaken by the Supreme Court in Sampson, applying somewhat of a lesser standard than the Supreme Court has applied in a probation context in Knights, and perhaps this court might do the same thing to also apply some sort of lesser standard under Article 14 when comparing probation to parole.
But under Sampson, can the government search the person of a parolee for absolutely no reason.
Yes, in Sampson, it was a police officer who observed somebody walking down the street. The police officer knew that this person happened to be on parole, and based on that alone, conducted a search. There was no warrant, and there was no particularized suspicion whatsoever. It was simply the fact that the person was on parole that warranted the search. And the Supreme Court said that that did not violate the Fourth Amendment because of because of that totality of the circumstances analysis that the Supreme Court has undertaken.
So under your analysis, if I'm a parolee and a parole officer comes to see me and says, I have no basis to search your home, but I'd like to do it, do you consent to that? And I say no. Is that a basis to revoke my parole for lack of cooperation?
Right now, the way that the parole board might be interpreting the lack of governing case law, perhaps that would be permitted. Again, that is the issue before this court, and I'm not suggesting what exactly the standard should be, only that the standard should be something less burdensome than LaFrance. So if this court does choose Sampson, then yes, that would absolutely be permissible.
And if we set a standard, I don't quite understand how we enforce it. Because we never see the case again. The parole board is the final arbiter.
Unless they're criminal charges, of course.
I'm sorry, what?
Unless they're criminal charges
Right,
that result from the
unless
search.
we have a case like this one where it does come before the court.
So I take it your position is that a parolee can have his or her person and/or residence searched for absolutely no reason at all, and they're in exactly the same position or status as an inmate in the inmate cell.
I am still hesitant to say that the parolee is in the same position as an inmate because there are certainly types of searches that an inmate would be subjected to because of institutional requirements and the utter lack of Fourth Amendment rights, or rather Article 14 rights. So there is a difference, but I do agree that a parolee, as the law currently seems to stand, could be searched without.
Or at least as the parole board's regulations permit.
Right, as the parole board's regulations permit, as investigations deemed necessary. And if I can, I would just like to very quickly address an issue raised in my sister's brief, whether the New Hampshire parole condition actually did apply here. And just to very quickly say, it absolutely did. There is a difference between New Hampshire regulations and the conditions of parole that this defendant was subjected to. The conditions of parole traveled with him. The regulations did not. So when he was in Massachusetts, he was indeed subject to both conditions of parole, and we find support for that looking both in his application to transfer in Officer Jackson's testimony and looking at the Interstate Adult Offender Compact for Supervision.
Well, can I ask you a question, Anna? I'm sorry to keep you here. So let's say, for instance, that we conclude that reasonable suspicion is necessary to conduct a search of a parolee in Massachusetts.
Yes.
And let's conclude that New Hampshire has a very different condition in their parole requirements. Person comes, is transferred parole here. Does that mean Massachusetts law applies to a subsequent search, or New Hampshire law applies?
Massachusetts law would apply, and it is in the Interstate Compact for Adult Offender Supervision that if the receiving state is unable to enforce a special condition imposed by the sending state, then the receiving state should so inform the sending state and resolve the dispute. So I think that would take care of any issues.
Thank you.
Thank you.
Thank you, Your Honors. I'll rest in my brief.
May it please the Court, I'm Nancy Dahlberg on behalf of the appellee Lawrence Moore, and I'm asking this Court to affirm the allowance of the defendant's motion to suppress evidence obtained from the warrantless search of Mr. Moore's apartment. I'm going to start by just addressing a few things that were just raised, and then I'm happy to go through what's in the brief. I'm not 100% sure whether the Commonwealth has conceded that reasonable suspicion is required for a search of the parolee's person and his apartment. I think the Commonwealth did. So
I'm not so sure about that.
Oh, okay then. Let me go back.
I mean, what I thought I heard was that that the standard for searching an inmate in the inmate cell essentially apply to a parolee and the parolee's place of residence, possibly with the exception of the kinds of searches that might be undertaken on the basis or on grounds of institutional safety and health concerns.
So let me go back. my argument is that the motion judge was correct in holding that under Article 14, and we're starting from this constitutional premise of, a right to privacy, if it really from probable cause and search warrant, but backing up a step, we're with LaFrance, because the judge said the same standard should apply as in LaFrance. So in LaFrance, the search requires at least reasonable suspicion of a parole violation or other wrongdoing, and a search warrant, barring application of a traditional exception. As the motion judge stated, there's no difference that would lead to the application of a different standard of right to privacy between parolees and probationers.
But how do you account for the fact that a person gets parole, a person who gets parole, essentially is being supervised by, I'll use the term Department of Corrections employees, parole officers here, just as if they were serving their sentence. The only difference is they are serving their sentences out in public,
Well, I would
as
say
opposed to behind
there's
a certain set of walls.
Yes, Your Honor. I'm not nearly as eloquent as the dissent in Sampson, and I'm not going to read from that right now, but they did a much better job than I did articulating the fact that whether there's a different procedure, you've got a parole officer, you've got a probation officer, you've got the same purposes, rehabilitation and protection of the public by the same means, supervision outside the walls of the prison. And I can go on, and actually the motion judge did a very good job doing that. I'm sorry, Your Honor, yes. So the fact that, in fact, the systems are the same.
However eloquent it may have been, it was a dissent.
It was a dissent of 3 justices whom I know this court admires, but more to the point, in LaFrance, the court basically endorsed the dissent in Griffin, where Justice Blackmun, according to Justice Wilkins, had the better of the argument there on search warrants.
But are you, I appreciate that you can put these two and it's rehabilitation is the purpose, but there really are differences between probation and parole, lots of differences.
Well,
and most importantly, the point that parole is completely conditional, operated by an executive agency, and it is really a discretionary decision by the parole board. You can't appeal if they decide not to give you parole. I mean, so you're in just a very different status than you are as a probationer.
Well,
in terms of your
there may be some difference between probation and parole, but the difference between parole and imprisonment is much greater. And I would certainly argue that if the Commonwealth is currently operating on the basis of suspicionless, warrantless searches.
I'm sort of focused on, okay, reasonable suspicion, but what about the warrant requirement?
Oh, get to the warrant requirement? Well, so the argument in LaFrance, in rejecting the majority opinion in Griffin and going with the dissent, was that there was no reason that the warrant requirement in all contexts deters impulsive or arbitrary governmental conduct, does not impede protection of the public and rehabilitation, the goals of probation as well as parole, and was not an undue burden for a parole officer to obtain. In this particular case, they had detained the parolee in jail, took his keys while he was in jail, and went and opened his apartment. The judge found the parole officer and the police, because this was a team effort, could easily have obtained a warrant. And the fact that the parole board has this discretionary power, and the court has pointed out, who's overseeing that, argues in favor of the warrant requirement. In fact, there are no, I'm sorry, Your Honor.
No, go ahead, please finish.
No, there aren't any regulations that talk about the right to privacy of parolees or lack thereof. There are no regulations in the parole and there's no statute, there's no regulations. The fact investigations as necessary certainly doesn't speak to this issue. And on top of that, there was no language in the Massachusetts Certificate of Parole addressing this issue at all. So,
Isn't there, I keep hearing this voice in my ear that says, if you go with what the defendant is saying, we're not going to grant parole to anybody. Because if we don't have this level of supervision, we don't want to take that chance.
well, I'd like to address that and then just go back for a minute to the record in this case and what we know about parole in Massachusetts. The same argument certainly could have been made about probationers at the time that LaFrance issued.
Except that parolees are in jail, and they're getting this huge benefit of a conditional freedom.
Yes, but as I discussed, I do have a footnote in here. In terms of our system in Massachusetts, Sampson had all kinds of statistics about California, recidivism, number of people on parole, all that kind of thing. In Massachusetts, you could have a parolee on parole for a crime much less serious than someone's on probation for a crime much more serious than some crime that someone's on parole for. You can get parole from a district court case. You can get structured sentences where someone gets a probation on a related case in which they've just served time. So there's nothing in this record that suggests that we're dealing with a whole different population of people, and I would argue that we're not. Professor
What's interesting, just structurally, probation officers work for the court. When you're on probation, you're under court supervision, right? Parole officers don't work for the court. They work for an entirely different branch of government with an entirely different set of rules and regulations. They allow people the privilege of going free from prison and serving their sentences in the community.
Well, as the statute, and I'm sorry I don't have it off the top of my head, but as cited in Cole, people are supposed to be released on parole when they can exist in society, with supervision. This is true of people on probation as well. And the argument that I think, responding to the court's concerns here, in favor of a search warrant with the, availability of traditional exceptions is stronger in the parole context because the court doesn't otherwise have oversight. And as I said, in this particular case, it's a perfect example of why you should get a search warrant. There was no reason not to.
We don't have oversight over the revocation of parole either, really, do we? Someone's parole is revoked?
So we're starting here, the state can set up a parole system, the state can set up a probation system. We're talking about Article 14 and the right to privacy, and we're kind of ratcheting down from the standard that's required. When the court thought through in LaFrance what the goals of the probation system were, how it operated, is it going to be impracticable, a word I don't really like, to get a warrant? Those issues really do apply in the parole context. And, the dissent in Sampson basically used the words beyond fathom to describe why the differences between probation and parole raised by the majority should make a difference in terms of an expectation of privacy or right to privacy of parolees. The fact that in Massachusetts, there isn't even the statute that they were talking about in Sampson. There isn't even the regulation that they were talking about in New Hampshire. There is nothing to suggest that even an agency of the Commonwealth has seen it fit to articulate that they're going to be doing this. And I would reiterate that I think what the Commonwealth has described as the current situation is not constitutional.
Could we go back for a minute to
Sure.
the judge's decision that there was no difference between probationers and parolees? That seems a little cavalier to me, and if that turns out not to be the case, does the logic of the judge's decision to apply LaFrance crumble?
Well, so what the judge said, and if I may, because I thought he did a nice job, both categories of defendants are at liberty in the community. Both categories of defendants are subject to state supervision for the same purpose and through similar means. There is little, if any, difference between probationers and parole, either in the need for government supervision, which they have, or in their expectation of privacy.
Yeah, I get that. What I'm trying to ask you to focus on is if we disagree that there are no differences, where does that leave your argument about the application of La France?
Well, so indulge me for 1 minute. The dissenting justices in Sampson agreed with the majority that parolees typically will have committed more serious crimes than probationers, although I don't think we can say that about Massachusetts, and that unlike probation, parole follows a period of incarceration. However, they concluded that, quote, "Why either distinction should result in refusal to acknowledge as legitimate when harbored by parolees the same expectation of privacy that probationers reasonably may harbor is beyond fathom." That's where the eloquence comes in. The Commonwealth provides no argument to the contrary. There's nothing about the parole system that would attack the right to privacy when you're talking about these dual goals that are the same. The statute that establishes probation, and I don't have the language right in front of me, basically allows for parole when someone can live in the community, the public is protected, they're also supposed to be supervised for rehabilitation, they're supposed to get help with employment, and so on. They come from a different point, but again, whether the crimes are more serious, whether they need more supervision, I think is an open question on this record. But it doesn't go to the right of privacy because the goals are the same. The need for checking impulsive or arbitrary governmental conduct is the same. The ability to fulfill the constitutional requirement is the same. And I think it's a very heavy burden to depart from that. I think that's what La France says.
But the standard is reasonableness, correct?
Well, under La France, that's the overall standard, but the analysis under La France is that reasonable suspicion is required.
No, I know.
It's not a totality. Okay.
But the constitutional standard is what is reasonable, and in La France, we said for a probationer, what is reasonable suspicion. So the question is, what is reasonable to search a prison cell versus what is reasonable to search somebody who has been released from a prison cell and is finishing his or her sentence on parole. But one fundamental difference is that the person on parole is still finishing a sentence. You get a 5 to 7. The judge has authorized you to be in prison for up to 7 years. Parole board says, no, we will put you on the street and allow you to serve that remaining 2 years on the street. Does that change the view as to what is reasonable with regard to the search of that person on the street?
Does it change the view as to whether the balance struck in La France should be the same as for parole?
Right.
It doesn't. They should be the same, and the Sampson dissent called a faulty syllogism the suggestion that prisoners and parolees ought to be treated the same. The logic is this: prisoners have no legitimate expectation of privacy, parolees are like prisoners, therefore parolees have no legitimate expectation of privacy. That, to the dissent, was a faulty syllogism. I would just go back to thinking about Article 14 as having a requirement. The purposes of both probation and parole were seen in La France as being satisfied by reasonable suspicion and a warrant subject to traditional exceptions. The Commonwealth has not established any reason to depart in what I would think is necessary to call a departure from the standards that were thoughtfully set up by this court.
All right, thank you.
Thank you, counsel.
Thank you.